All right, good morning, everyone. Good morning, good morning, good morning. I'd like to call to order the Judiciary Committee public hearing for Wednesday, September 20th, 2023. We're here in special session to take up a judicial nominee. Any remarks from my co-chair? From the ranking member? We're short of ranking. Stand at ease for one moment. All right, any remarks from the ranking members before we get going? Thank you, sir. All right, moving right along then. Nominations for review. We have one to take up, which is the nomination of Nora Danahy of Glastonbury to be an associate judge of the Supreme Court and associate justice, it should say. Our agenda is incorrect. Associate justice of the Supreme Court and judge of the Superior Court. Attorney Danahy, if you might stand and raise your right hand for me, please. Do you swear to tell the truth, the whole truth, and nothing but the truth? Nope, that's not what it is. It's yeah. Do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God, or under penalty of perjury?
I do.
Great. Have a seat, and whenever you're ready, we'll hear your opening statement.
Good morning, Senator Winfield, Representative Safstrom, Ranking Members Senator Kissel, Representative Fishbein, Vice Chairs Senator Flexer, and Representative Quinn, as well as all distinguished members of this committee. My name is Nora Danahy, and I'm very honored and humbled to be here before you today. I want to thank the governor for the nomination and for the confidence he has placed in me. I'm 62 years old. I was born and raised in Willimantic. I attended public schools and graduated from Windham High School. My mother and father have both passed away, but I'm sure they would be very proud of me sitting before you today. My brother was a Superior Court judge and is now a JTR, and my other brother, some would say, had the wisdom not to become a lawyer. My sister lost her battle with drug addiction and died in 2006. I'm married, and my wonderful husband, Len Boyle, is here today. He's completely supportive of my nomination. One of the best aspects of marrying Len is that I became a stepmom to 3 amazing individuals and their spouses. I'm now blessed with 5 grandchildren. I graduated from Wellesley College and went directly to Harvard Law School. After law school, I came back to Connecticut, where I have remained. I clerked in the federal courthouse down the street on Main Street in Hartford for Judge T. Emmett Clary. I loved my clerkship and learned so much from him. He respected all who came before him and had a deep belief in the rule of law. After my clerkship, I went to Dayberry and Howard and learned from very fine attorneys. During my time at Dayberry, I worked on civil litigation matters, which included attending short calendar on a regular basis and second chairing a medical malpractice case. I then joined the U.S. Attorney's Office as a prosecutor after 3 years at Dayberry and Howard. I stayed in the U.S. Attorney's Office for almost 20 years in various roles, including being the first woman to serve as acting U.S. Attorney. At the U.S. Attorney's Office, the following principles guided me. Make decisions based on the evidence, not emotions or personalities. Treat everyone, victims, witnesses, defendants, court personnel, counsel on the other side, with respect and dignity. And finally, work to achieve one goal, justice. This may sound high-minded, but it was real. The job was not about getting a conviction. It was about doing what was right, which often meant not presenting a case to a grand jury for indictment after investigation if the charges were not appropriate. My job for many years was to evaluate fairly and impartially the evidence developed in the course of an investigation and determine whether, based on a fair and appropriate application of the law, the government could prove the elements of a statute. This skill set and traits are ones that should guide a judge, and I would be honored and humbled to have the opportunity to apply these principles as an associate justice. At the U.S. Attorney's Office, I initially handled a variety of cases, but then focused in an area for which I had a passion: protecting vulnerable citizens from those who preyed on them financially and holding the powerful accountable to the rule of law as all other citizens. For most of my career, I dedicated myself to matters involving public corruption and abuse of the public trust. After the U.S. Attorney's Office, I moved into the civil litigation arena and became Deputy Attorney General for Connecticut under Attorney General George Jepsen. As the deputy, I supervised the operations of the office, which included exclusively civil litigation, and provided advice and counsel to state agencies concerning Connecticut statutes and case law. In my role as the deputy, I chaired what is called the Litigation Management Committee, which reviewed and made recommendations to the Attorney General on whether to bring a lawsuit, steps to take in the course of litigation, how best to defend a matter, and whether to settle or resolve a case. During my time at the AG's office, I also argued a case in the Connecticut Supreme Court and the Second Circuit. I left the Attorney General's office to join United Technologies in 2013, where I was eventually promoted to the head of the Global Ethics and Compliance Unit. As Chief Compliance Officer, I worked with a team of international lawyers to investigate allegations of corruption, financial impropriety, and other legal and policy violations. I represented the company before federal U.S. regulatory agencies and the Department of Justice. I returned to the Department of Justice and the U.S. Attorney's Office in Connecticut in March of 2019 with the intent to focus on investigations involving entities that manufacture and dispense opioids. Shortly after returning, however, I was asked to join what has been called the Russia investigation. I was confronted in the late summer of 2020 with a situation where my conscience would not allow me to remain, and I resigned from the U.S. Attorney's Office and from the Department of Justice. I then became counsel to Governor Lamont in March of 2021, in the middle of a legislative session and the COVID pandemic. Needless to say, I had a steep learning curve and one that I had to master very quickly with the help of the lawyers in the governor's office, members of state agencies, and members of the General Assembly and their staff. As many of you are aware, as the General Counsel, I was involved in providing advice and counsel to the governor, his office, various state agencies on all aspects of state law every day. I left the governor's office at the end of his first term and joined a small law firm in Hartford. The lawyers at the firm are outstanding lawyers and great people, but my heart is in public service. When the governor offered me this opportunity to return to public service, my heart said yes. I hope that you find I've developed a skill set as a lawyer in both civil and criminal matters that will be valuable on the Supreme Court. If confirmed, I will work hard, stay humble, approach every matter from a position of impartiality, apply the law fairly, and treat everyone respectfully. Thank you, and I welcome your questions.
Thank you, Attorney Danahy, and congratulations on your nomination.
Thank you.
Appreciate you running through your resume for us. You alluded to a situation that led to a slight gap in your resume in late 2020 and into 2021. And obviously, one of the things this committee needs to look at in evaluating your nomination is your decision-making and how you make and handle tough decisions, which clearly you will face on a daily basis on our Supreme Court. Could you elaborate a little bit more on that situation and your decision-making process that led you to leave the U.S. Attorney's Office in late 2020?
Thank you. Yes, Representative. Before I get to the crux of what caused my resignation, I do want to address the issue of me first initially joining what some have labeled the Trump DOJ. I didn't return to the Trump Department of Justice. I had been at the Department of Justice during the George H. Bush, Bill Clinton, George W. Bush, and Barack Obama presidencies. During that time, I had also worked directly for both Republican and Democratic U.S. attorneys. Politics never played a role in how I was expected to do my job. That is the Justice Department I thought I was returning to. I had been taught and spent my entire career at Department of Justice conducting any investigation in an objective and apolitical manner. In the spring and summer of 2020, I had growing concerns that this Russia investigation was not being conducted in that way. Attorney General Barr began to speak more publicly and specifically about the ongoing criminal investigation. I thought these public comments violated DOJ guidelines. In the late summer of 2020, just months before the 2020 presidential election, he wanted a report written about our ongoing investigation. Publicly, he would not rule out releasing that report before the presidential election. I had never been asked to write a report about an investigation that was not yet complete. I then saw a version of a draft report, the conclusions of which I strongly disagreed with. Writing a report, and particularly the draft I saw, violated long-standing principles of the Department of Justice. Furthermore, the Department of Justice has a long-standing policy of not taking any public actions in the time leading up to an election that might influence that election. I simply couldn't be part of it, so I resigned. It was the most difficult personal and professional decision I've had to make.
Thank you, and thanks for filling that in for us. You know, it dawns on me that as we sit here in the Judiciary Committee in Connecticut, the Judiciary Committee in Washington is also gaveling in today. A hearing of which it seems the import of is to poke political holes on both sides of the aisle, I might add, as to ongoing investigations of the DOJ. And it strikes me that for whatever reason, folks are trying to politicize or trying to influence decisions that are made by the DOJ. And I think it's refreshing to hear, at least from your experience, that there are still folks who appreciate the nonpartisan nature and role that the DOJ can and should play. So I guess my question to you then is, how do you believe that translates to our court system? I think, you know, we have seen, particularly in Washington, but some might say even in state courts around the country, a more political nature, less apolitical tone to some courts around the country. How do you think your prior experience translates to being able to ensure that our Connecticut Supreme Court remains sort of above the political fray, so to speak?
I think it translates in this way. My experience with the Russia investigation and my decision to resign, I hope reflects my unwavering commitment to the rule of law and to fairness and impartiality. And I think that is a way in which courts can stay out of the political fray, to stay true to the rule of law, to approach any matter from a position of impartiality, to listen to the arguments, be open to the arguments of colleagues and of course the litigants, but at the end of the day, not compromise fundamental principles.
So I asked you a little bit, obviously, about your own internal decision-making and how that translates, but how can you talk at all about before you left the DOJ? Did you try to influence or sway or tamp down the actions of others around you, be that Mr. Durham or Mr. Barr or others? And again, if you can, I'm particularly interested in how you believe that experience translates to being an associate justice on the Connecticut Supreme Court, and how you would bring or what skill set you believe you bring to that role in that job.
The answer is I did. My immediate boss was obviously Mr. Durham, and I raised concerns with him. I would be naive to think I had really any influence over the Attorney General of the United States. How that translates to, if I am so lucky to go forward, being a member of a multi-member court, I wouldn't be in a position of them being my bosses. It would be colleagues. And I think that makes a difference. So I would always, as I said, be respectful of their views. And similarly, if I had a view about an issue, I would not be hesitant to voice that, defend it, maybe defend it again. Listen to their arguments of my colleagues as to why I was wrong. That I think is really important, listening. So I'd like to think I am persuasive. Obviously, I wasn't persuasive in the Russia investigation, but with colleagues and others who similar would approach in a case or a matter with the idea that what we're looking to do here is to get it right and to apply the law, I am very up for having frank discussions and defending my positions.
Well, let me switch gears, ask you a couple quick questions about your questionnaire before I turn this over to my colleagues. I'm sure have questions as well. One of the questions we always ask is, do you believe the Connecticut Constitution provides same or greater protections than the US Constitution? And you indicated that the Connecticut Supreme Court has determined in some instances the protections afforded under the Connecticut Constitution are greater. I was wondering if you could just give us a couple of examples of where you believe our precedents as a state provides greater protection for individuals than the US Constitution does.
I think the case that sets out the principle that the Connecticut Constitution provides greater, not less, protections for individual rights is Kerrigan versus the Department of Public Health, where the court found that a statute that prohibited same-sex marriage was unconstitutional under the state constitution. Another example is a case called State versus Marsala, in which the Connecticut Supreme Court found that the good faith exception to the exclusionary rule did not apply under Connecticut law. So what that is in the federal system and under the federal constitution, if a court finds that evidence or a search warrant was defective, but there was a good faith belief on the part of the police officer because a judge signed off on it and it was more of an administrative issue, the good faith exception would allow the evidence to come in and not be suppressed. The Connecticut court has found that the exclusionary rule is more than just about teaching the police the right and wrongs of getting a warrant. It's about the warrant process as a whole to include the court so that they didn't adopt the good faith exception to the exclusionary rule. I think those are two, in different arenas, two examples that come to mind.
And then one of the other questions that always really interests me on this form is number 15. The one about whether the balance has begun to swing too far in favor of criminal defendants and against the ability of police and prosecutors to do their job. And frankly, I'm not sure you really gave us an answer to that one.
Okay.
So I wanted to sort of ask it again and ask you to sort of address that issue for us.
I actually I tried to give an answer, and because I believe the balance, but it's all the criminal justice system, there's always a balance between how to protect individual rights and liberties and how to ensure that communities and neighborhoods are safe. There's always that balance. And it is really exclusively in the legislature's arena to determine at points in time where that balance has been struck. And, you know, I will, maybe you can correct me. I know that there's been legislation, you know, that's called generally the Police Accountability Bill passed that reflects a balance in that arena. I respect that completely. I will apply that law according to the dictates of the rubric as a judge in terms of looking at the plain meaning and what was intended to if raised with any questions about that. So it's not too far or not far enough. It's a question of what the balance should be in any given point in time. And that's really an arena that I respect you all to work in.
Yeah, I guess my question is a little bit more, less on the police accountability side, more on the how we prosecute crime side and the type of sentences that are handed down and the way we look at our penal system as playing a role in society, you know, and you know, I think a lot of us, maybe not all of us, but a lot of us on this committee believe that this legislature and certainly the federal government went too far in the 1990s and the early 2000s. And the tough on crime era was a colossal failure. Crime rates were higher. More folks got locked up, particularly from communities like mine in Bridgeport. And as somebody who was a prosecutor during some of those days and has hopefully seen some of the evolution, I guess what I'm trying to do is give you an opportunity to weigh in on how you think the system has changed from your early years of practice in the U.S. Attorney's Office to now, and what impact that has had.
Two points to that. First of all, I don't disagree that in the response in the 80s and 90s to violent crime and drugs, in terms of imposing long mandatory minimums, long sentences, has shown to be a massive failure. And I see through the laws that are passed here and in other states and even the US government, a movement away from that. And I respect that. And given what happened or what we saw happen because of that, I think it makes a whole lot of sense and is the right direction to go in. When I was a prosecutor, as I said, I didn't do drug cases and violent crime. I did some felon in possession cases early on. So I can't speak to me personally and what I stood up and said or didn't say in connection with those kind of cases. It just wasn't what I was focused on. I'm not excusing it. I'm just saying it's hard for me to put myself personally in a situation where I was asking for a mandatory minimum because it wasn't really the kind of cases I did. The public corruption and financial fraud cases were, the sentencings were not along those same lines. In terms of, I think, your other sort of question about the role of the penal system. I mean, obviously, people should be held accountable appropriately for their crimes, but also if somebody has served their time and is moving on with their lives and has shown that they are, not recidivists and they have a clean record, they should be provided the resources and means to move on with their lives. I hope some of the defendants, even in the public corruption and financial fraud arena, I have no reason to think they're not moving on and leading productive lives, and that's a good thing.
All right, one pass the microphone. Representative Fishman.
Thank you, Mr. Chairman. Good morning, Attorney.
Morning.
Kennedy. Nice to see you again. When did you get approved by the Judicial Selection Committee to be on the list?
Approved, I believe it was December of 2013.
Okay, so that was certainly during the Malloy administration. And at that time, did they approve, they just generally approved you to be on the bench? Or it was my understanding that Ascension, so to speak, that they have a different panel questions analysis. Am I incorrect in that?
I don't know what's happening today, so I'll speak to in 2013 when I went filled out the questionnaire. I think I filled out the questionnaire in July of 2013, went before the committee. There was no separate, separate or subcommittee for different courts. And it was just, I was asked about which courts you were applying for. And I sort of checked the box, or in my cover letter made it said all three. In part because I didn't know any better. I wasn't being presumptuous. I just thought they asked me, so I'll tell them. But there wasn't a separate process.
Okay. So where were you in your resume in 2013 that you decided to try and follow that process?
I had, when I went so in December of 2013, I had just joined United Technologies. And becoming a judge was always something that I have had an interest in, but I wasn't thinking, oh, I'm going to do it tomorrow. But it seemed like a good time to at least express my interest to the Judicial Selection Committee.
Okay. And your knowledge or your experience in state court, I think I was paying attention. You were at Dayberry and Howard, and you characterized it as attending short calendar. I've been to tons of short calendars, right? And I've been before the judge and I've argued motions and that kind of stuff. Attending is where you accompany somebody else and you sit in the gallery. So
Yeah.
can you just explain your involvement with
Sure,
short calendar?
sure. No, I participated. In short calendar. Dayberry and Howard was a large law firm, but a young associate like me at the time, I did go to short calendar and represent a client. I didn't just sit in the gallery and watch a partner do his or her thing.
And at Dayberry and Howard, you were doing civil litigation.
Yes.
And what kind of cases? I know because they are a large firm and they have, different segments, right? So what segment were you concentrating in? I
was in the commercial litigation segment. I worked a lot with attorney Tom Groark on one of the first cases I worked on, and it was still ongoing, was a issue about the safety of the plywood in McDougal Correctional. So we represented a company in connection with that. I was involved. I did do some work with another attorney, Fran Morrison. That was my opportunity to second chair a medical malpractice trial with him. So I did that, and I'm trying to think of other specific sorts of cases. They were mostly large commercial cases. I wish I could remember it because on one of these cases, I was sent to Portland, Maine in January to go through boxes and boxes of documents. It was before we had a lot of e-discovery. So I did a variety of large commercial cases and some smaller. I did a lot with the lemon law and representing some of the car manufacturers when people had made lemon law complaints. I did that. So a variety of matters, but all in, as I said, all in the civil and commercial arena.
And did you handle any of those cases yourself, or it was always part of a team?
The sort of going before the agency for lemon law, I handled those myself. Going to short calendar, arguing motions, I did that myself. I sat with another associate by ourselves in Portland, Maine, going through documents and for that. So it was a mixture, but I know there were other times, obviously the second chairing the malpractice case, I was more of an observer. I think I maybe argued a couple of motions in connection with that trial, but I wasn't doing the trial, no.
In the lemon law cases, did you ever represent a consumer?
No, not at Dayberry. No, I did not represent a consumer.
So that's one of the things that one of the critiques that I've heard of your resume is, representing the blue collar man on the street, sort of. Is there any part of your resume that extends to that?
If you look, I should add, I lost a lot of those lemon law cases. So for the consumer, they ended up on the better side of it. So, but I don't know, maybe I shouldn't admit that to this committee, but I guess we're in terms of representing the consumer or the average person, I'd have to refer to my time as at the U.S. Attorney's Office and the financial fraud cases I did and the victims in those cases. Yes, I stood up on behalf of the United States in court, but the victims in those cases, I was representing them, not representing in the legal sense. I was protecting their interests, where oftentimes through people, and several times it was lawyers, much more powerful than them, had really taken them for a ride in terms of taking their money. So although they were victims in the case and I didn't represent them as a lawyer, the cases I did were on behalf of them as victims.
And you refresh my recollection. I think at one point, did you get involved in the case with Timothy Burke, where he had bilked all these people out of, it was the foreclosure scandal, and I thought I ran across your name. Maybe I'm wrong.
Okay, yeah,
Okay.
it's not coming to mind, but
That's
I
good.
don't,
Okay.
that doesn't mean I
It's
didn't.
that kind of case.
Yeah,
So,
yeah.
In the questionnaire, question 6 in particular, you were asked, do you think the Supreme Court ever got it wrong, and in what case? Now, you'll note that it doesn't say the US Supreme Court, doesn't say the Connecticut Supreme Court. However, you chose to go federal here. So what was wrong? I mean, I read your answer, right? You selected Dobbs. It's the politically correct sort of selection. I got it. But, when I read Dobbs, I read it as a states' rights case. I'm not gonna get into the, abortion and all that stuff because, why was it wrong though?
And I'll hit that. I had a lot of, I left that question blank for a long time because I was thinking, is it US, is it state? And elsewhere, the form talked about the state constitution more specifically. So that's when I went back, but I appreciate your comment because I wasn't sure how to answer that at first. So more substantively, how I think Dobbs got it wrong is, first and foremost, they took away an individual right. And that is, I don't think has ever been done before. Secondly, they, without, I think, a strong basis, which there has to be under both US and state law, they rejected stare decisis. They turned their back on precedent. And finally, they tethered individual rights to a historical perspective. So they look to whether there was the legal framework for abortions back in 1868, when women were essentially owned by their husbands, when women couldn't vote, and then determined what a woman's right should be based on that sort of construct. And I don't ascribe to that sort of approach to determining what the words of the Constitution mean.
So when the Supreme Court US, just dealing with right now, decides to go against its precedent, they are wrong.
Not necessarily. But I think the precedent in Roe, in Casey, and in other cases that the Supreme Court has decided about the individual right to privacy emanating from a liberty right, that if they're going to reject all of that, they need to do it for a sound legal reason, that for some reason this was just wrong. And I don't think if you read the majority opinion in Dobbs, they did that. So I'm not saying you never, a court should never overturn precedent, but and I know the Connecticut court has made clear, it needs to be that prior decision is wrong and terribly so. And that's not the legal, there is a legal term for it, but essentially that's what it means.
Yeah, I think it's egregious, but
Yes.
I mean, I think that the Dred Scott cases would be a better example, right? Because we certainly abortion, that right states are able to codify, but recognition of someone based upon their skin and whether or not they have value is something a lot more dramatic. And certainly I think that the US Supreme Court got it wrong originally on that. But
I agree.
can you bring it to the state perspective? Has the Connecticut Supreme Court ever gotten it wrong?
I can't sit here today and tell you, talk about a specific case, nothing. But I guess what I can say is that the Connecticut law, when looking to Connecticut Constitution and determining what a word or words mean, in a case of Geisler, they've set out the factors, 6 factors to consider. And one of them is a historical perspective, but it's not dispositive. So the concern that I especially saw with Dobbs was that tethering a right to a historical framework. And I don't think that is the case under the Geisler factors. That's not dispositive. It's a much more expansive review of factors to determine what the Constitution means. And clearly it is meant to be a Constitution that endures for the ages. So that I think is a difference in how we see cases decided in Connecticut under when a constitutional provision is being interpreted. But I can't say that I have a case that comes to mind right away that I could speak intelligently about.
So I just want to give you an example, the death penalty. The Connecticut Constitution expressly talks about capital crime. Capital crime is the death penalty. The Supreme Court, Connecticut Supreme Court says for certain reasons that we're going to get rid of this. But the people of our state did not remove capital crime from the Constitution. So did the Connecticut Supreme Court get it wrong?
I can't opine on that without really looking at the Constitution and whether there's the equivalent of cruel and unusual punishment. And I know the case, I know the name of it, Santiago, and look at that. And I'd want to be better informed before I say it's right or wrong. And I just am not that well informed today.
That's fair. Just one other area
Sure.
is the supremacy clause. And I don't know if Justice McDonald was before us a few years ago. We had a discussion about marijuana. You know, certainly the supremacy clause in the U.S. Constitution says federal law trumps state law. So, and this isn't a litmus test question. I'm just trying to, you know, does the supremacy clause exist in Connecticut? What is your opinion?
And I'm not laughing. It's in the marijuana field. I think it's a good question. The supremacy clause does exist in Connecticut and in the country. And I think the marijuana issue is particularly brings that into perspective because a subset of the supremacy clause in terms of preemption, I think is something you have to look at. So under Title 21 of the US Code, marijuana, possession, distribution, still illegal. States, not just Connecticut, have either legalized marijuana, recreational marijuana, more recently, medical marijuana. The Department of Justice has issued memos saying that if it is a well-regulated structure for medical and or recreational, we are not going to step in and put our resources in trying to dismantle that. So they've indicated in terms of preemption that that's not the direction they're going in. However, and maybe this is to your point, they could still in the federal system bring a case of possession. And the fact that it's legal in Connecticut wouldn't be a defense. It would be federal law that's being applied. But that doesn't mean that two sovereigns under these facts can't coexist with conflicting laws.
Well, just, the problem, well, there's many problems, but, when somebody goes to purchase a firearm in Connecticut, they have to do a federal form, 4473. And one of those questions is, if you answer yes to any of those questions, you can't get a firearm. One of those questions is, are you the unlawful user or possessor of any controlled substance? And it expressly says, we don't care what your state has done. You can't acquire a firearm if you're a user or possessor. So it's sort of like entrapment, basically. But that's more me. It's not a question. It's me opining.
No, it's, and I think that one's front and center right now in the news. So I appreciate that.
Well, I thank you. And yeah.
Senator Kissel.
Thank you very much, Chairman Staffstrom. Good morning and congratulations, Attorney Danahy.
Thank you.
I don't believe we've ever met in the past, so just a few questions. First of all, one of our famed editorialists and observers of the, as he phrases it, the Capitol Village is Kevin Rennie, who is a former colleague of mine from the Connecticut State Senate way back in the day. And he wrote an article, some questions that should be asked, and I certainly can't address all of them, but one of them had to do with when you worked for United Technologies, which apparently now is Raytheon. And I'll just preface by saying like a life story that actually occurred to me. So when I first started practice 39 years ago, probably 2 years into practice, it was with a small firm up in Enfield. Apparently my dad, who worked for a corporation in Bloomfield that had electronic technology manufacturing business throughout certain countries in Europe, was chatting with some folks, and all of a sudden I got a letter from some guy that I did not know from Italy saying, would I consider being put on retainer because he'd like to send me like $1,000. And I go, what the heck is this? This is crazy. I'm just, doing title searches for a small firm, some, criminal defense work, maybe some personal or injury matters. And this was out just crazy. So I called my dad, who, God bless his soul, has passed on. And I said, do you know who this guy is? And he goes, oh yeah, I told him I was bragging about you just becoming an attorney. And he probably wants to get on my good side. So, how, and so the guy's from Italy and maybe this is how they do business there. And so as someone who married someone of Italian, Calabrese, Sicilian descent, this is not disparaging the good people of Italy, but for whatever reason, this guy thought, hey, I'm going to make friends with this guy's son. And so obviously I wrote him back, this guy in Italy, which was a pain in the butt because I had to do international mail and say, thanks, but no thanks. And that was the end of that. So I say that as an introduction to the question, because United Technologies at the time and now Raytheon does business with all these countries, and their standards of ethics is probably different than what I would consider appropriate here in the United States of America. And by using this as an example, a real life example, I don't want to like say, oh, it's got to be some third world country. I don't even know if that's politically correct to say anymore, but even our European NATO partners have different standards. And so I'm just wondering, I thought Mr. Rennie asked an interesting question. How did you go about advising this multinational corporation based here, in much of our folks employed in Connecticut, when dealing with all these differing ethical standards and ways of doing business?
So when I joined United Technologies, I joined what was called the Global Ethics and Compliance Group. And that at the time, the company was putting a lot of resources and thought into what their compliance group should look like, in part for some of the reasons you say, that their ways of doing business around the world were not necessarily in line with US laws. And part of my job was to develop policies, and I shouldn't say develop because they had them, but improve on, make more robust policies concerning improper payments, what you just alluded to, and to make those policies, train people on those policies, both in the US and outside of the US, that the company had no tolerance for improper payments. And then when after, in terms of the policies, the more, I would say, interesting part was if there was any allegation that someone in the company was either had offered, was involved in any kind of improper payment scheme, And there was a lot of robust systems in place for people to make complaints anonymously. The company had hired me and others to investigate that and to determine whether in fact it was verified. And if it was, there was consequences. Typically, someone lost their job. In addition, a short time after I got there, a scheme of potential improper payments of some magnitude was uncovered. And there was, and I can say this because it's been in public filings, the company made a disclosure to both the Department of Justice and the SEC about that and cooperated fully in providing information, laying open its compliance policies and systems for the department, and at the same time figuring out from what we saw with this particular matter, how we could improve on that. And at the end of the day, the department declined and the company settled with the SEC. And that went on for several years while I was there, and I remained involved in it both when I was an investigative attorney and when I became chief compliance officer. Every quarter, as the chief compliance officer, reported to the audit committee of the board. And part of my job was to let them know where the company stood on issues of improper payments. So it was very clear, both by policy and by culture, that the company wouldn't tolerate improper payments. I'm not going to say they never happened, but when they did and the company knew about it, resources were put in to investigate it, and people did lose their jobs. And if it was of a certain magnitude and the right thing to do was to make a voluntary disclosure, the company did that. And those are not easy decisions to make, but and it was, as you know, and it employed a lot of people in Connecticut, but it employed a lot of people around the world. You can't always control behavior, but they had a very robust system in place to ensure that, or to do their best to ensure that business was not obtained by paying bribes.
And I find that really reassuring, and I appreciate the depth of your answer regarding that. So thank you for that. I believe it's, and again, I'm not an expert when it comes to corporate law, but I know in my experience on an annualized basis, we have to, I believe under Dodd-Frank, sign a certificate that if there's any improprieties in the chain of command, that you have to acknowledge that you would report it up the ladder of authority. Did you ever, in your experience, and again, no need for specifics, but run into, because occasionally you'll hear stories of large corporations that have major contracts and they're on this path. So there's a lot of money involved. Forget about, and it's critically important to the individual, their jobs, but it could also be tens of millions of dollars for shareholders, profits, things like that. They've already established the construction of certain items. There may be problems. Did you, in the area of ethics and dealing with other companies or in your bailiwick, whatever you were charged with supporting, did you ever run into resistance where you really had to sort of dig in your heels and say, hey, listen, this is pretty black and white. This is black letter law, and you guys really have to do something about this. And I'm just wondering, and this applies to your new role. I have no doubts that you're going to be affirmed and serve for the next 8 years on the Supreme Court, which is fabulous. And I'm really excited for you. But it's going to lead to some of my other questions. Did you have to dig in and push back?
When I was at United Technologies, I never had to dig in above. So whether I reported as chief compliance officer, I reported to the general counsel, who reported to the CEO, who sat on the board and reported to the board. It was never, in fact, sometimes it was, whoa, let's wait till the investigation's done before. There was really no tolerance. It was, I won't say pushback, but there were times where, particularly at the sales level, when someone was close to a deal and the ask was, well, we want you to hire this consultant. And it wasn't a crazy amount of money. And it would have to come through an approval process. And that's where the training and the need for training comes in, because you'd have to, and I did, sit down with the salesperson and say, okay, who is this consultant? Why do you need them? What will they do? Who asked for this consultant? And they just wanted to get the deal done. So they didn't think in that way. They didn't think, as a compliance person, was my job. So not push back, because ultimately we had the final say that we weren't hiring that consultant. But there was a give and take and a dialogue that I engaged in on those kinds of issues with people who just weren't thinking that way.
And I appreciate that answer as well. In fact, the corporation that I work for part-time in my other life, we have online training on an annual basis when it comes to those things. And they very much stress that. And again, the hiring of an outside counsel could be a means for another party to try to funnel money either to the company to grease the skids, or to funnel money to some outside party that's affiliated with them. So there's all sorts of warning signs that should pop up when you run into that. And I appreciate your rigor. And it's comforting to a large extent, because unfortunately, in talking to my constituents, maybe it's just because we're bombarded with more information all the time. And it's easy to get jaded about the way of the world, the weaponization of the Department of Justice, no matter how you feel about different administrations and all of that. Part of that questioning was because I wanted to lead to my next area, which was several years ago, I had the good fortune to get an inside tour over across the street at the Supreme Court building by whom I still consider my good friend and colleague from the past, Justice McDonald. Although over the years, I don't know if he still feels the same way, but I certainly admire him and everything that he's done in his career. And when we were over there, and I'm going to do a shout out to the people across the street. We used to have annual meetings between the Chief Justice and members of the bar and members of this committee. Or I was either at a hotel, or sometimes we would have meetings over there. I'd like to see that again, Mr. Chief Justice. So I'm just doing a shout out, and hopefully they'll hear that. But we haven't done that in years, but Justice McDonald actually gave me a private walkthrough as well, and showed me the conference room that you will be at when you're debating where you come down on certain decisions, right? And he said, you wouldn't believe some of the fights that we have in this room. And sometimes they're shouting, and there's really, so it's not genteel, Attorney Danahy. You are going to have an opinion. And I got concerned when you said, far be it for me to think that I would be able to influence the Attorney General. I would think that you could. As someone who loves history, has a degree in history, one of the things I'm looking at now is the court packing plan by President Roosevelt, and where that all went, and the interreactions actually after the Congress in 1930 pulled away Oliver Wendell Holmes' pension, and that caused a lot of more conservative justices to decide they didn't want to retire. It's a whole giant thing. But one of the things that I've learned is that President Roosevelt didn't want obsequious supplicants around him all the time. He looked for people with differing opinions, tried to gather all that information, and then made a decision. Then he was very stubborn about, once he made a decision, sticking with it. So I just would like to think that, yeah, maybe you couldn't influence directly the Attorney General, but I would hope that the system would have allowed you to at least offer an opinion and let it sink in. That is going to be what happens when you become a justice of the Supreme Court. And so how do you feel about your past career? And, you know, will you be able to like duke it out with these folks that have been sitting over there for years now? Because you believe this is your opinion of the case, the facts, and you're not really re-looking at most of the cases on factual bases, but the law, it's really determining what is the law when it's applied to what's before us. And I guess, I don't expect you to sell yourself out, but are you going to be able to hold your own? Are we going to be proud of you for digging in so that I can read a decision and go, you go, Justice Dan, hey, way to go.
The shorter answer is absolutely. The longer answer is, when I said far be it from me to influence the Attorney General, I didn't mean that I didn't raise my concerns, and I didn't mean that there wasn't shouting at certain times. I just didn't change it. And that's why I resigned. I think if you ask anyone that I worked with, shouting, maybe that, not so much my style. I tend to be on the quiet side, but if I believe in something and I think it's the right way to go, you can ask a lot of FBI agents, a lot of IRS agents. I know how to make my point. I know how to stick with my point, and I know when and I know how to change minds. I'm not going to tell you I'm always successful, but I'm up for the task.
Yeah, and I think this is an iterative process. Again, I don't have any doubts that you're going to be confirmed. And it's good that you're already thinking in terms of I can mix it up with the best of them. And however your methodology is, if it works for you, all the better. One of the things that I found really reassuring when I talk to my constituents and they sort of get it, Connecticut's a small state. Seems like everybody knows everybody else after a period of time. That may be presumptuous on my part, but I say that because when I read that your dad, who has passed now, served on the Supreme Court, one of the things that's assuring to me is that I've got to believe that after you get sworn in and some quiet moment when you're over there, after you've been confirmed, and maybe maybe before you hear your first case, or maybe when they give you your office, or at some point, it's just going to be you and dad, right? And you're going to just sort of say something like, I hope I can live up to your expectations. So I don't think you're ever really going to be truly alone over there. Maybe this is my spiritual side coming out. And everybody has heard me rant on, I'm a Christian, and I'm not proselytizing, but I just sort of feel like you're going to have that angel on your shoulder, like double checking you. And so it's not only like you're just new to this experience, but I think that do you carry with it this sort of like, I've got big shoes to fill and I don't want to let you down. Does that cross in your mind as you're moving forward through this process?
Not in that way. I mean, I am incredibly proud of my father and what he accomplished. I'm not blind. I read where, somehow at 62 years old, and he died in 2003. I'm still riding his coattails. They're very long. So, I'd like to believe I got here because of what I did, but I thank him often for what he instilled in me, for the support he gave me. And sometimes it wasn't always easy support. I was telling the Chief Justice this morning, I lost my first trial and was devastated. And my father looked to me when I was telling him, bemoaning, oh my gosh, this is, the sky's falling. He said, that's not about you. You are there to represent the people and to do the job for the people. So get out of your own head and do your job. So it wasn't always easy advice, but yes, I am humbled. I am, touched, and the fact that I can say, thanks, Dad, grateful.
Well, that's good. That's really reassuring. And we have some colleagues that have had parents on the Supreme Court, and they got to be pretty rigorous folks to be extraordinarily proud of, but again, setting a very high bar at the same time. I don't know if you can comment on this, but we talk about looking at opinions. I want to get away from the federal side, but we had a decision here in the state of Connecticut regarding guns and whether manufacturers should be held liable for bad things done with a gun. And I believe, our state Supreme Court ruled yes. And I think that is now on its way to the United States Supreme Court. So it's out. I believe that case, at least as far as you commenting on something that's pending here in Connecticut, I think you're freed from worrying about that. unless you feel like somehow it could get bounced back down here when you're on the state Supreme Court. So I just, give me your take on that. And if you feel like it's too much of a bramble bush and you got to stay clear, I'll accept that as well.
Okay. I do believe that I can't opine on a case even that is, particularly one that's still in the pipeline, if it is on its way to the US Supreme Court, because I don't know enough about the ins and outs to say it definitely won't come back to Connecticut. And I also think that there's a lot of questions that are going to be raised about the rights of gun owners and gun manufacturers to come. So if I do offer an opinion here, what part of the concern is if I am so lucky and honored to be moved forward, under the Code of Judicial Conduct, if a judge comments on a matter outside of the court or an opinion, such that it looks like they are taking a position, they have to disqualify themselves. And so I just don't want to be put in a position where I would have to do that if I opine on a case, particularly one that isn't concluded.
Fair enough. We have tons of really excellent jurists. You've been extremely instrumental. And by the way, I want to compliment you on certain batches of new nominees that we had come before us. And I believe that you were very much involved in one of the largest cohorts that we had in recent memory. And I think most of us on this committee believe that it was a really good batch of new nominees. So that's, again, to the extent that you helped handpick that with Governor Lamont, great job. And I think we're all in Connecticut well served by that. But one of the criticisms also is that, hey, we've got great jurists that have worked their way up. They've spent time in the Superior Court. Now they're in the appellate bench. And now you're sort of like parachuting out of left field and just landing right on the state Supreme Court. And gee, if I've been like in the trenches on the judicial branch for 20 some odd years, I might just go, I'm not going to say it would affect the day-to-day decision making because we have too many professionals out there to let that happen. But it might be a little bit discouraging at the same time, right? And so what do you say to those people? The fact that you don't have any experience as a judge, I think you have an excellent resume, a variety of jobs. But what do you say to the folks that you're now going to be opining on their decisions that they've been there for decades, and now you're just, boom, landing on the state Supreme Court?
I don't sit here today with any notion that I'm the only qualified person. I think there are many sitting judges who are qualified and would do a great job in this position. But I do think I bring a varied legal career and a perspective that will be helpful on the court. But as one of my bosses, who then went on to become a district court judge and a Second Circuit judge, said, I didn't get 100 on the judge test. There is no test. And I am honored and humbled to be here. I've done a lot and worked hard in different positions to get here. And I worked with the governor. I'd like to believe that he saw my legal acumen and thought I would be a good addition to the Supreme Court. So it doesn't mean I'm better, I'm smarter, or anything else. It just means I too am qualified and there are others.
And for what it's worth, I agree with Governor Lamont. I think you're an excellent pick for the state Supreme Court.
Thank you.
One of the things during when we had those batch of new nominees, there was occasionally, and I believe there was one that withdrew her name, but she was sort of rushed through. There was a question whether she could even practice in Connecticut. And the issue came up of how fast did that person get before Judicial Selection Commission and then before us. And it is not a criticism of her qualifications, but like when Representative Fishbein asked you when you applied, and it was about 9 years ago, that's sort of reassuring. So it's not like, oh, Governor Lamont thought that Attorney Danahy would be fabulous. Let's rush her right through in 3 weeks. But like, how does it work when you're the governor's counsel? You like that, I'm assuming that you were involved in that. How does that, I question the rushing of people through the process, because despite their really good qualifications, to my mind, it sort of causes an undermining of our confidence in the system. In other words, I don't think that there's a set period of time where you have to sort of wait and then get nominated. Certainly, for example, just last week, I had a status conference with Judge Genario, whom I have the utmost respect for. And I had the pleasure of serving with him back when we were both, when he was a state senator. And then he became the secretary of the Office of Policy Management. And everything that I hear about Judge Genario is that he's a fabulous jurist. But I do know that as Governor Rell's term was coming to an end, he sort of like sailed through right at that end period. So yeah, I'm used to I've been lucky enough to be doing this for 31 years now. I've seen people sort of on the fast track, but that one seemed inordinately fast. And when even an individual nominee's ability to practice law, like whether they've even been in a Connecticut court, I just wondered what happened in that particular one. And do you have a process where, you know, you're willing to do this for certain individuals? How does that work? This is like we're sort of you're an interesting candidate in that you've been the governor's counsel, and you can give us that sort of behind the curtain of the Wizard of Oz scene a little bit, to the extent you feel comfortable doing that. Can you give us a little insights on those super fast track nominees?
The example you're citing was not so much a fast track nominee for judicial selection, but after that, when the person was being considered, it turned out that both the Judicial Selection Committee and me did not appreciate that she had not been admitted to the bar in Connecticut. That was the portion that was rushed, and because of that didn't work out well. And she's a good person. So I hate to say more, but that was, I think, a wrinkle in the process that had never happened before. And it wasn't caught at Judicial Selection Commission, and it wasn't initially caught by me because I was going by, not an excuse, it wasn't caught by me.
No problem. I hate to end on a bad note, like, sorry, I pushed her through. But again, I'm going to leave it on a positive note. I think you're going to be an outstanding justice of the Supreme Court for the people of the state of Connecticut. I have no doubt that this nomination is going to fly through. I have great confidence in you and your moral caliber and legal skill set. And with that, I know other folks want to ask questions. So congratulations. And thank you very much, Chairman Staffstrom.
Thank you.
Thank you, Senator. Representative O'Day.
Thank you very much, Mr. Chairman. Good afternoon. Or,
Good afternoon.
good morning still, sorry. Just a few follow-up questions to what's been discussed so far this morning. First, congratulations for being in that chair. As the good chair pointed out in his question about why you resigned, I too had some concerns about that. We obviously don't want someone who's going to resign from the Connecticut Supreme Court on a disagreement with the rest of the bench. And I know that's not a concern that I have now, based on your response. I will say keeping politics out of the government and the judiciary is a paramount concern of mine. I will tell you, I was very disappointed in the FBI, very disappointed in the CDC. I think a lot of our governmental entities got infused with too much politics. And so it's refreshing to hear that you are not concerned or predisposed to bring politics into the Connecticut Supreme Court. As I understand, testimony here. Is that correct?
That is very correct.
I will say, I did sit on judicial selection. I was not there when you came through. When did you come through for the Supreme Court?
I went through for all three courts at the same time.
Okay. All right. I did not, if I read that, I forgot it. So as of December of 2013, you got approved for all.
Yes,
Okay. The answer, look, you clearly have the intellect. You clearly have the temperament. I've heard nothing but great things about you from people who have worked as colleagues in civil litigation. But if you look, I think you'd admit not being a sitting judge is a experience issue. And we do have a fairly deep bench, both in the Superior Court and I would say in the appellate court. How would you address, and you have a little bit already in your opening remarks and in some of the answers, but how would you address those that have concerns about your ability to jump right into the Supreme Court? It's been done in the past a couple of times, but how would you address the concerns that some might have about that issue?
I would address it this way. I have spent my career, particularly at the U.S. Attorney's Office and the Department of Justice and at UTC, developing evidence, assessing a record, determining what the evidence meant, evaluating it, looking at the applicable laws at issue, whether as applied to these facts, the government could prove its case, or whether the government, in case of UTC, had a case to be concerned about. So I think that is a skill set that would serve me well particularly on an appellate court. Looking at the record, determining whether the law, what it means and whether it was applied correctly. And then in terms of writing, I have done a lot of writing, and as I sort of was preparing for this and asked at the writing samples, a lot of what I've written over the past, more current years is privileged. So there wasn't a whole lot other than from my time at the U.S. Attorney's Office that I could make available. But I like to write. I know how to write. So I think those two combinations suit me well. I like discussing the law. I enjoy sort of getting into it and learning from others and taking in someone's perspective and thinking about it. I like to be told I'm wrong, and then figure out whether I really am. So I think I have the skill set and, as you say, the temperament to do the job without taking away that there is a deep bench and some really fine attorneys in Connecticut, judges and attorneys in Connecticut.
Your first response to one of the questions from the good chair, I actually didn't remember the question as much as the answer. You commitment to the rule of law, fairness, impartiality, courts stay out of the political fray, following the rule of law. I mean, obviously, that's something as someone who the good chair knows, I carry around the U.S. Constitution and the Connecticut Constitution in my pocket. And so I will admit, when you just answered one of my questions that you could admit when you're wrong, I will respectfully submit to you that you and I have a fairly big disagreement on number 6. Because when you've got a U.S. Supreme Court that did Dredge v. Scott, that did the Buck v. Bell forced sterilization, that's still law, that did Karamatsu versus U.S., the internment of Japanese, Plessy versus Ferguson, and Bowers versus Hardwick. Those are all horrible decisions, in my humble opinion, much worse than Dobbs, which I consider, with the good ranking member, to be a states' rights issue. I understand the politics of it. And I would submit that our Congress has let us down yet again in not getting involved when they should have, and the Supreme Court has gotten involved on a number of occasions on that issue. But putting that aside, why do you believe the Dobbs decision is worse than those 5 that I just pointed out? I mean, it says the question is, do you think the Supreme Court, not Connecticut or US, not distinguished, ever got it wrong? And in what case or cases, because the S is in parens, what did they get wrong and why? Those cases, to me, jump out much more than the Dobbs decision. But why did you pick Dobbs as opposed to any of those others, if at all?
I picked Dobbs because I think that the tying the availability of a right, an individual right, exclusively to a historical analysis doesn't do justice to the Constitution. It certainly doesn't do justice to people living today. And also is not square with other more recent cases where they want a different result. And I use the cell phone case for example. The majority of the court has found that the search of a cell phone is unreasonable without a warrant, even incident to an arrest. There is no, if you look at the Fourth Amendment about protecting your people's homes, papers, and effects, there's no way to say what was the legal framework for a cell phone back in 1868. And yet they found that there's a right of privacy there. So I think the tethering rights to exclusively a historical analysis doesn't comport with what I understand the Constitution, both US and state, to be.
All right, I appreciate that. And the reason why I asked that question was because of your response in 6. And you said that the majority rejected without sound reasoning stare decisis, but I just gave you a list of Supreme Court cases where I think they should be reversed. And so do I understand your response that while stare decisis should be followed with sound reasoning, without it, it shouldn't be followed? Are you I'm trying to read your answer and understand how you're looking at the stare decisis issue, and you put in there without sound reasoning. So I read it to say that your intent of that is that, if there's sound reasoning behind going against a prior decision, you could see that, but without sound reasoning, which you didn't believe existed in Dobbs, that's why you think it was such a bad decision. Am I reading too much into that, or is that in essence what you were saying?
That's part of what I was saying, but I think in looking at it, I probably could have been stronger about rejecting stare decisis. I don't think they followed, and I'm sorry, I don't have the standard off the top of my head, but it has to be egregiously wrong. I don't think they followed that standard. Some of the cases you cited were egregiously wrong, separate but equal. I mean, I don't think we don't even need to talk about it. So, and I don't think that was the case in Dobbs. I mean, if you look at Roe, if you look at Casey, it was good law. What happened?
Well, okay. I don't want to get in a debate over that. I think whether it was good law or not has been decided, but as I understand your answer, irrespective of your personal opinions, you're willing to follow the law as it is written and as the legislator writes it and prior courts have decided. Do I understand that correctly?
Absolutely. I will follow if the statute is clear and unambiguous and look at its relationship to other statutes. There's no need to go beyond that. And I will follow that. I will follow it faithfully. and I will be impartial.
Thank you. And I do want to commend the chairs and rankings for the new questionnaire is very well done, because a number of my questions are now already there. So I don't have to ask any more questions. I congratulate you
Thank
again.
you.
I do think that you'll be a fine jurist on the Supreme Court. I would have liked to have seen other candidates potentially from the Superior Court bench and the Appellate Court bench, but I have the utmost respect for you and the governor's choice. So
Thank you.
thank you for your time.
Thank you for your brevity, Representative. Further questions or comments from the committee, Representative Osborne?
Thank you, Mr. Chair, and thank you so much, Attorney Dennehy, for being here today. And congratulations
Thank
on your
you.
nomination. I echo the sentiments of many of my colleagues. I'm confident that you're going to be a fine jurist, and I wanted to take this opportunity to ask you some of the questions that are on the minds of not just myself, but many of my colleagues who practice in state court and in family court in particular. And two of the things that I think are relevant to the conversation we're having today. One of which, there's been a conversation in general about the need for diversity on the bench. And diversity can come in many different forms, diversity of background, diversity of education, diversity of qualification, and diversity of life experience. And that last one's a little more difficult to get on the bench because you've got to have people who have gotten through law school and practiced law and who are now at a point in their lives where they're being considered to decide some of the toughest issues that really impact the lives of our residents, because that's who usually uses the state court system. So getting that diversity of background and diversity of life experience is especially difficult when you're talking about family court issues. And family court is really one of the toughest assignments on the bench, because the litigants don't have the right to a trial by jury. Both the law and the fact are found by the judge themselves. So the judge is simultaneously judging credibility of litigants. They're trying to figure out what the real facts are, and they're trying to apply the law all at once. So certainly in that arena, somebody with a diversity of qualification, particularly people who have experience practicing in state court and in family law, would be a particularly advantageous assignment in the family court arena, because they can draw on that depth of qualification. And the importance of that really bubbles up to the Supreme Court level, because 75% of all family law cases now have at least one party who is self-represented. So if you have a judge who knows what the law is in that arena already, even if those parties don't have an attorney themselves who knows what the law is, they're more likely to get an outcome that is actually in line with what the law is. And the reality is that family court cases, Superior Court is the one and only shot, unless they're extraordinarily wealthy. They're not making it to the appellate court, and they're certainly not making it to the Supreme Court if somebody gets the facts wrong. So that's just kind of my little soapbox for that issue. It's something that my colleagues and I discuss a lot, how important that diversity of qualification would be there. And it would really impact you in your time on the Supreme Court, because you will be deciding cases that concern the best interests of children. And many of the factors that Supreme Court jurists are permitted to consider when they're reviewing a family law case are standards that shift sometimes dramatically and quickly in the realm of societal expectations and acceptance. So, what is in the best interest of a child, whether from a parenting standpoint or from a legal standpoint, that is shifting very quickly in our society right now. And I'm curious about, when you talk about the stare decisis and egregiously wrong decisions being ones that are ripe for stare decisis, perhaps not being the dispositive decision. Where would you fall on those cases? Because at the time a case starts, by the time it gets up to the Supreme Court, what was in the best interest of a child from a societal viewpoint in 1990, by the time it gets, in year one, it could be year 5 by the time it gets to the Supreme Court, and it might be a very different societal expectation. So, putting on your cap of understanding that, only those things that are clearly wrongly decided by the family court, by the Superior Court judge. How would you balance the application of stare decisis and the statutory factors and the shift that takes place? And I understand that's a really nebulous question, and I'm just interested in your thought process, because a lot of us are grappling with that very question right now.
I'll answer it this way. Obviously, at the, trial court, Superior Court level, the judge is in the best position to make factual determinations when it's, certainly not a jury trial. And as a Superior Court, as a Supreme Court judge, if I am so honored to move forward, I would be very faithful to the standard of whether those were clearly erroneous in terms of factual findings by the trial court, because I respect greatly the job of a trial court judge, and that they are sitting in the position to best assess the credibility of witnesses. And I would be fair and impartial in applying that standard of review. And obviously, if it's a question of law in terms of what a statute means, it would be a de novo review and would look appropriately and at whether, as applied, the law was applied correctly. And that would be, as I say, de novo, and I would take that seriously and appreciating the sort of emotional difficulties of family cases.
Thank you. And with respect to diversity of qualification, do you have any ideas as you sit here today on how we can diversify the qualifications and the backgrounds of the people who are ultimately confirmed to be judges in our state?
As you say, I agree. Diversity of background is very important. And I know when I was in the governor's office, it's important to the governor, particularly racial and ethnic diversity. So when I was there, the governor and I met with the heads of the Affinity Bar and the dean of UConn Law School and the chair of the judicial selection to talk about that, to how do we encourage lawyers to want to become judges. So, I think that's an important piece of it in terms of just getting people interested in the job from all aspects of life. And it's not as easy as it sounds, but I think that needs to continue. And maybe there are more that can be done. But I don't know a specific, obviously the Judicial Selection Commission weighs all sorts of factors in determining who to approve to move forward. But the governor he can only go with what's on the list.
Thank you very much. And I just wanted to say, I am confident you are going to be our next Supreme Court judge. And I am confident that your analysis and your intellectual and academic rigor will be an asset to this state. So thank you very much for your time.
Representative Callahan.
Thank you, Mr. Chair, and congratulations, Attorney Danahy. I know it's been a long morning so far.
Thank you.
many of my colleagues have touched on the questions that I have in reading through the questionnaire and the answers you provided. On number 22, you talk about what United States or Connecticut Supreme Court justice you admire, and you brought up Justice Kagan, and you talked about how you admire her judicial philosophy. Can you tell me what you admire about her judicial philosophy?
Two things. She has said publicly, we're all textualists. So I think what she means by that is we all have to start with the text of whether it's a constitutional provision or a statutory provision. And so, putting labels on it is, that's where there may be divergence after that, but she was upfront on that idea. And then she described herself as I think it was a common law constitutionalist, but that she looks to the statute, she looks to the words, she looks to precedent, and she looks to principles that have come from those precedents. So I think that's a very practical and common sense way to approach a case. And if you look at some of her writings, she is concise. She's clear. You can, a lawyer can pick up and read her opinions, but a person who's not a lawyer can do the same and understand it. And I think that's very important.
Thank you for your answer. And in addition, moving to a different topic, a couple of my colleagues have touched on the fact that you haven't been served on the bench. At this point, with your nomination, if you're confirmed, my last count, I believe I'm correct, would be 5 out of 7 justices who have no experience on the bench, no trial experience on the bench coming into our Supreme Court. And I'm concerned about that. And also you talked about, we have some very qualified people on the lists. Likewise, there are some very qualified, experienced Superior Court judges on the list that you have, as Senator Kissel said, parachuted over. And that concerns me because as we're trying to bring in good Superior Court judges, they should also have aspirations to rise to the Supreme Court or the appellate court. And in this case, you're going to be asked to sit in judgment of trial court judges in their cases, having never sat there. How can you talk to me about how you can do that effectively?
The skills that I've developed as a lawyer.
Can you just speak a little closer to the mic, ma'am?
I'm sorry, I've moved it here because I'm looking at you. The skills that I have developed as a lawyer in terms of developing evidence, assessing evidence, similarly looking at a trial court record. I've done that in different situations, with a prosecutor hat on, with the hat of a in-house attorney. So I've done that. I have had different positions where I've been immersed in state law. And I'm not saying I know every state law but I know where to start, how to research. And I think that's very important in terms of the kinds of questions that come up to the Supreme Court. So I do feel that my experience has given me the skill set, but again, hearing your concerns and the concerns of your colleagues, I understand, and I'm not suggesting that there aren't others who are qualified.
Thank you for your answers. And again, I mean, no disrespect in going down this road.
Understand.
It's just that we have a judicial branch with a lot of employees who see that the meritocracy of doing a good job on the bench and serving is kind of cast aside in this case. But I have no doubt you're a very competent attorney and would make a good Supreme Court justice. So I appreciate your answers, and thank you, Mr. Chair.
Representative Dubinsky.
Thank you, Mr. Chair, and thank you very much for coming in. The discussion so far has been very enlightening to me. I see from your resume that we probably trod some of the same ground. I'm not sure our paths have ever crossed, in any of these short calendar appearances, but perhaps we've seen each other in the halls. I wanted to circle back to your discussion of your time at the Justice Department. You, and correct me if I'm wrong, it seemed like you indicated that you felt that the Justice Department was not handling this Russia investigation correctly. Do I have that right?
I felt that the actions of the Attorney General in the spring and summer of 2020 were not in line with the principles and guidelines at the Department of Justice. Excuse me.
Okay. Do you have any indication that that investigation was not handled properly?
I have, after I resigned on September 11th of 2020, I had no further involvement, so I really can't speak. It went on for quite some time and I can't speak to how it was done.
Yeah, I'm not
I-
asking you about what happened after you left. I'm asking you about what happened while you were there.
What I was involved in involved classified, highly classified information, and I really can't get into what happened when I was there because I likely would or potentially could get into an area that I can't speak about.
Okay. Was it your feeling that that investigation was politicized in some way?
It was my view that by the summer of 2020, actions of the Attorney General were not in keeping with department principles.
Okay. In a political way?
It was certainly taken in a political way by reports. Whether he intended that or not, I don't know.
Okay. Do you know if any other Justice Department employees quit for the same reason as you did?
I know a colleague who was on the team left the team, did not leave the department, but it was after I left. So exactly why and what prompted it, I can't speak to.
Is it your belief that the results of that investigation found that President Trump did not collude with Russia to influence the 2016 election?
The Russia investigation wasn't focused on that question. I think that's a question of what the Mueller investigation found.
So what was the investigation that is at issue here?
It was a question about initially questions about what steps the intelligence agencies may have taken in connection with gathering information regarding the Trump campaign. And it expanded after that to looking at the actions also of the FBI.
Okay. Is it the role of the courts to address the merits of a political candidate's claims that an election was a result of some type of election impropriety?
Not sure I understand the question.
Well, there is a line of thinking that courts should stay out of those disputes, that if a candidate believes that an election was not conducted properly, that that is a political question that the court should stay out of. So I'm asking you what you believe the court's role is in addressing that type of issue.
Can't really answer that without having a lot of additional facts about the specifics of the issue and whether there are particular statutes at play or laws at play, and individuals have a good faith basis of bringing a lawsuit versus whether it is purely a political question. Without more, I can't answer that.
Okay, would it be fair to say that the courts do have some role in addressing those issues depending on the facts and the circumstances?
It's possible, but I can't give you really more than that without a lot more facts and a lot more thought.
Okay. Whether or not it is generally accepted, there is a widespread feeling amongst at least conservatives that the Justice Department is currently selectively prosecuting conservatives over people on the left. And essentially giving many liberals a pass. So for example, there is a widespread belief that the January 6th riot defendants are being given far harsher punishments and prosecution than, for example, the Antifa riot defendants. And there's I could give you a dozen examples of things like that. As a justice, what consideration would you give selective prosecution when you see a disparity in prosecutions in the prosecutorial discretion of a Justice Department or at the state level, and you can see that it's politically biased? What kind of consideration would you give that type of situation?
Representative, that question has a lot of assumptions in it about the reasons for bringing any particular case. And so what I can say is that I respect the separation of powers and I respect the role of the executive branch in making determinations about what cases to bring, and it's not the court's role to decide that. I respect the legislative branch and whether, for whatever reason, they want to weigh in and, make, from a policy perspective, make laws about that. So without more, I think it would be irresponsible of me as a potential jurist to opine based on an assumption that there is selective prosecution. I can't do that.
Okay, so if you see, for example, two people who are both arrested for essentially identical crimes, and both are found guilty, and the recommended sentence is 10 years, and the other, the recommended sentence is a couple of months of probation. And it appears on its face as if the only difference is political ideology. To what extent would you bring that into your reasoning when the defendant who was sentenced to 10 years challenges that sentence and comes before you?
Having been involved in sentencings for many years and many different types, what I would say is it's rarely two similarly situated individuals. So given your example, two individuals, same crime. Let's just say we have two accountants, bookkeepers. They both stole $2 million. One did it to go down to the casino and have a good time. Another did it because their mother was ill and they were trying to get her into the hospital for some best care. One was a Democrat, one was a Republican. There's so many factors that go into a sentencing decision. Should the person and why they did it and their whole picture be taken into consideration in imposing a sentence? Yes. Should their political parties matter? No. So, I don't see the example you give ever being a real one because people are complicated and a court judge in sentencing should look at the full picture of who someone is.
What about if you notice a pattern over the course of time and over the course of multiple defendants that are before you, and you see the same pattern over and over? Does that not factor into your reasoning at all?
Again, without having specifics before me, I can't venture what would be a sort of a wild speculation about a potential or, hypothetical case. I just am not able to do that.
Okay, do you acknowledge that over the last 10 years, there has been some degree of prosecutorial discretion that has been biased politically?
The one thing I have learned is what is reported publicly by the media about cases isn't always the full story. And so I rarely, although I read, I rarely assume that we're all getting all the facts that may have gone into a decision to bring a case or not bring a case. So not being on the ground, part of any of those decisions, I really don't feel I'm qualified to offer any opinion.
Okay. In a case that comes before you, would you have all that information?
At the appellate level, and if we were reviewing, say, a sentencing decision, I would like to believe would have all that information.
Attorney Danny, Representative, just a second. It's now noon. We've been going for about 2 hours. I don't know how many more questions the representative has, but we do have a couple more people signed up to ask questions. I don't know if you need a break, a bathroom break, or
I'm good if everyone else is good.
Okay, all right, proceed.
Thank you. You talked, in response to the questioning of a number of my colleagues, you talked about stare decisis. Where in the Constitution, state or federal, is stare decisis?
I'm not sure that it is.
You're not
I mean,
sure
it's
that
a
it is in the
judicial
Constitution.
principle that has developed over time.
Why is it so important that a court follow this principle that is not in either constitution?
Because I think people deserve some certainty, some understanding, some consistency in the law, and it shouldn't change because because there's different people deciding how the law should be analyzed.
Okay, you had indicated that you thought that the Dobbs decision was wrong because it took away an individual right. Is that, did I interpret that correctly?
Yes.
Um, and you were asked about what happens if a court, if the decision that a court is analyzing is just flat out wrong. My question to you is, if a court creates a right out of whole cloth, that's not anywhere in the Constitution, it just says you now have an absolute right to, to do, anything, to do something. What factors or what kind of analysis are required by the next court to say, no, that right was made up out of whole cloth. We're not going to go along with it.
I think the analysis when approaching any question of the Constitution and is to look at the text and determine whether it's plain and unambiguous. Typically with the Constitution, both state and federal, they're written in very broad strokes. So if it's not, then the next step, again, if you're in the state system, but to this, I think it's applicable to looking at the US, you would look at the factors that the Connecticut Supreme Court has set out in Geisler in terms of, you start with the text, you do look at the history, you look at precedent, you look at the principles derived from that precedent, you look at decisions of other states, you look at the federal government, you look at sociological and economic issues with the mindset that the Constitution is a document that is meant to endure for the ages. And a similar analysis is appropriate on the question of the US Constitution. You start with the text. If you need to go further, you look at history, but you don't stop there. You then look to principles and, precedent and principles that have derived from that in reaching an analysis of what that provision was intended to mean.
Okay. So for example, the Roe versus Wade case, for boiling it down to the simplest language, it essentially created a right to abortion by finding that abortion was within the penumbras and emanations of a right to privacy. And the Dobbs case found that that really isn't a proper basis on which to create a new constitutional right. Is that your understanding of how it worked?
Generally, yes, a little bit more complicated. I think it found within the liberty provision of the 14th Amendment a right to privacy that included a woman's right to reproductive freedom. It also included things like the right to, I think, same-sex marriage and other privacy rights, sort of the right to be left alone in the most private aspects of your life. And that included the right to a woman's reproductive freedom. I think the important thing is that that had been raised in cases after Roe and had been confirmed that that right was there. And what changed other than the court stopped at the historical analysis and didn't go beyond? And I think that's where, as I said before, I think stopping at the historical analysis is not appropriate given what the Constitution was meant to do.
Okay, well, the line of thinking with regard to historical analysis is something that is currently the current Supreme Court is using that in a number of areas of the law. Is that something that, as a Supreme Court, a state Supreme Court justice, you would be able to follow?
Again, if I am so honored to move forward, I would follow what the Supreme Court in Connecticut has said in analyzing the Connecticut Constitution. And those are the factors we talked about and are enunciated in Geisler and cases after that. The historical piece of it is one, but it's not the only, and it's not necessarily dispositive.
Now, you had indicated that it's important to follow stare decisis, and that if you're going to overturn a precedent, that you have to have, see if I have your exact language, I don't, but you essentially have to have sound reasoning for doing so. Is that the case even if the case before you that you're considering overturning was not based on sound reasoning?
I think I should have been stronger. I think it's stronger than just sound reasoning, but you are correct. Those were my words. So again, it's very hard for me to opine on something as sort of amorphous as that. I don't know how to answer it because the standard for not following stare decisis is, that it was almost egregiously wrong. And I think the facts and what we're looking at would matter before I could venture an opinion on whether or not something should be overturned.
That's fair enough.
Yeah.
With regard to stare decisis, is the length of time that a case has been precedent and the number of cases that rely on it, is that a factor that you would consider in determining whether or not to overturn an existing case?
I think in the analysis of, and again, I'm not using the exact terminology, but for purposes of our discussion, in the analysis of whether something is egregiously wrong, yes, I think you would look to whether it's been followed and the principles that derived from that.
I want to move a little bit to your time as the governor's counsel. Were you involved in advising the governor and or the executive branch regarding policies during the COVID pandemic?
As the general counsel for the office, I cannot speak about what I did or didn't advise.
I'm not asking you that. I'm asking you if you were giving the governor advice during that period of time.
I was in the office from March of 2021 through the end of his first term. So, January of 2023 or in December 2022. So, and obviously the pandemic was still ongoing and there were policies in executive orders in place. I worked with this branch, also the legislative branch, about extending and the legislature's involvement in continuing the emergencies. So I was there.
Okay, now I understand that it's sort of a fine line between disclosing what you advised, which I'm certainly not asking about, and whether or not you advised on a certain topic. Because I think it's important for us to know if you were an advisor to the governor when certain policies were implemented. So for example, the policies that shut down much of the state without telling me, without disclosing any communications between you and your client, were you involved in giving advice with regard to those policies?
I'll answer it this way because I do think we're walking a very, very fine line here, and
That's what we
as
do
you-
here.
And as you do too, I think we both respect the attorney-client privilege greatly. So I was not in the office in 2020 when many of the executive orders were first implemented. I came in 2021. I believe it was a short time after I was there that the Supreme Court handed down the Casey decision, which found that the civil preparedness statute gave the governor authority to issue some particular orders that were being litigated. I was in the office when the question came up about the role of the legislature, and then working with the leaders and others in having the legislature determine whether to continue the emergencies and what executive orders should continue and what should not. Some of that was a real dialogue with staff members.
Okay, and what was your role during that period?
My role was as the attorney to assess the orders, assess whether under the statutes they were addressing appropriate, they were COVID related or not. I don't have the statutes in front of me. So, I was looking at the civil preparedness public health statutes, analyzing those, looking at the orders, discussing with agency heads and folks at agencies, the purposes, whether they were still valid in terms of the need for the orders. And then again, getting into a point of it, then talking with the governor. But it was done with the intention of following the law and keeping the people of Connecticut safe. That was, the governor's main focus during that.
And was it your job to advise the governor with regard to those policies during that time?
It was my job to advise the governor on, provide legal advice to the governor on any of the issues that might be coming before him, which are, often and frequent. I was not I was not a policy person. I was a lawyer.
I understand. If any of those issues on which you advised the governor were challenged and came before you as a Supreme Court justice, would you recuse yourself from hearing those cases?
Yes. If I provided advice on a particular executive order, yes.
How are we to know which of those things you've advised the governor on to know if you are properly recusing?
And that's a fair question, and one I have thought about. If there is the appearance, simply because I was the general counsel at that time, an executive order was in effect, I would recuse myself. I'm being careful because I don't know, there's a lot of issues that I think we're going to see because of the pandemic come to the court. So I don't want to say something that turns out that I really don't need to recuse myself. But if it's an executive order, a question's purely on the executive order, it was in effect when I was there. And even if it had been put in effect before, but there was questions about continuing it, I will recuse myself.
Thank you very much. I very much appreciate
Thank you.
your answers. Thank you, Mr. Chairman.
Thank you, Representative. Senator Sampson.
Thank you very much, Mr. Chairman. And thank you for being here today, Attorney Denny. Congratulations on your nomination.
Thank you.
And thank you also for our one-on-one meeting. I appreciated meeting you very much. A lot of the things I might have asked you about today have already been covered. I generally the kind of person who likes to jump up first, but as a non-lawyer on this committee, I figure I'll let my colleagues who are more accustomed to discussing legal matters, take the forefront. And Representative Dubitsky actually really touched on a couple of things that I definitely wanted to get into. We certainly discussed in our meeting your time working as counsel for the governor and my concerns about the many of the policies that were put in place, certainly when it comes to the scope of executive authority. I don't mean to turn this into a speech. I do have questions for you, but I'll just say that this is a very difficult role that we play on this committee, and particularly for me, because I don't know necessarily what I can or cannot ask sometimes, and I'll try and stay out of trouble. I'm sure my colleagues will prevent me from overstepping. But I have only one real concern. When someone comes before me, I certainly respect the fact that the governor is, the chief executive of the state, and he's the one that gets to make the decisions about who he is going to appoint. And I have, great confidence that you'll succeed and be a member of our court. And I don't want to cast an opposition vote without good cause. But at the same time, I come from the school that I should be convinced to vote yes for things instead of have a reason to vote no. And the one thing that I'm having trouble with when it comes to your nomination is really a deep understanding that there is no chance that political activism will occur. To me, that's the only question I have for any judge or justice that comes before us. Period, is what is the chance that this person will take their politics into their job in any way? And I really appreciate your answers on that subject matter. You've been very forthright. You've been very forceful, in fact, in saying that you are going to interpret the law. But I will say that to me, it did raise an eyebrow when I saw that your response to number 6 was the Dobbs question or the Dobbs case. For me, I read that as a political answer based on our environment and our situation with the previous nominee. So, and this, listening to the dialogue today about your answers to your reasoning behind it also gives me a little concern. And let me just elaborate a little. We've been through this a few times, and I won't make you go through the whole thing again, but my understanding is that you believe that Roe was good law. That's something you said in your testimony here today. And you believe that the Dobbs decision was wrong, also your testimony. And the reason for that is that they relied more on original law than they did stare decisis or precedent. And I think that's been trod over a number of times here. My question is, now Dobbs is the law. And I'm curious to know whether, certainly this will probably not happen in your tenure as a Supreme Court justice in Connecticut, but how do you feel knowing that Dobbs is now the law of the land and would be precedent in a future case? I think you said the standard was it would have to be something egregious to go against stare decisis. So I'm just curious if you believe that the Dobbs case is so egregious that it would warrant being relitigated. Through you, Mr. Chairman.
You can answer.
So if I move forward, I would be on the Connecticut Supreme Court. I don't think there's any issue. There's a statute that provides a woman's right to get an abortion. The Connecticut Supreme Court has an analysis that sets out the factors, that doesn't stop at the historical legal framework. So I can't conceive that that issue would come before. But if it does, the question would be, can the Connecticut Constitution give a person greater rights? And that has been decided in cases like Kerrigan, that it does in the individual rights area provide for greater rights. And then whether that is a right that is in our Constitution would be determined by the Geisler factors.
No, and I can appreciate that. I'm not really asking for the purpose of what might come before the court in the future. In fact, I'm trying purposely to avoid that for all the reasons that are aforementioned. I found it interesting what you referred to as good law or egregious law, egregious decisions, and that sort of thing. To me, that's all I'm clinging to as a member of this body, trying to determine where you might fall in a political framework. And I think that's a credit to you, which is that you have not given us a lot. And I don't think there should be with any potential nominee, but there's definitely some. And it's important to me to know where you're going to stand on things. If you were in fact counsel for the governor of the state of Connecticut during a series of policy decisions that empowered the executive in a way that I didn't agree, and you were advising him that that was okay, I have a concern with it. Now, we won't know the answer to that question. We can't know the answer to that question. And I've tried both in our one-on-one, and I know that some other folks on this committee have attempted to try and garner some additional information from you on these topics. And for me, the only way I can comfortably vote in favor of a nominee is if they're going to share with me that they're going to have the same worldview when it comes to these issues that I do. And I just don't know that we've gotten there yet. Is there anything you might want to add about that topic?
The only thing I would add is, before I had the job and I was talking to the governor, I said to him, Governor, you don't want me as your counsel. because I'm going to give you the same legal advice I would give a Republican governor. I don't really want to be that involved as my predecessor in the legislative process. I'm sort of, that's just who I am, and that's where I'm comfortable in terms of acting as a lawyer. And he said, no, I do. That's what I want from the position now. So I can share with you, that was my sort of warning to him. Beyond that, I cannot tell you what I advised him or didn't advise him, but I will I will approach any matter from a position of neutrality. I will apply the law faithfully. And, I won't, unless somebody wants to hear it again, I won't tell you the analysis I will apply. I think probably you've heard it. So I guess I can tell you that.
Thank you very much. I appreciate that answer. There's only one other thing that I had written down in my notes that I wanted to ask from the beginning. It's kind of unrelated to any of the other conversation that we've had. And that is in the questionnaire on item number 14, which is the question regarding affirmative action. It says, do you believe affirmative action is proper to remedy discrimination? I think you did your best to answer that question, but there is a second question that says, do you feel hiring quotas are a legitimate tool in implementing affirmative action? And you didn't really provide an answer to that. I wonder if you might share your thoughts on that right now. Through you, Mr. Chairman.
Thank you, Senator Sampson. You may reply.
I didn't answer that because I think particularly today, questions about affirmative action are front and center, and whether they are constitutional are questions that are going to come up, and part of how to implement them would be, I think, to offer a view on whether they would be appropriate or not. And that would be, giving an advisory opinion on a matter that I think may very well come up to the court. And so what I tried to do, and I had a lot of trouble with this one because I wanted to be as forthright as I could and without stepping over things, was to say, in my life experiences, I've seen where affirmative action has given people, qualified people, opportunities they may not have had. And so that's my life experience. I'm not telling you legally where I would come down one way or another. I don't think it's appropriate for me to do that.
Yeah, thank you very much. I appreciate the answer. You see the difficulty I have, though. From my perspective, affirmative action is racism. It always has been. And I think it is equivalent to quotas. I don't think there's any way to do affirmative action without quotas. And this has been the big debate historically on the subject. And the purpose of the survey, I think, is for us as members of this committee to have some basis to understand where someone's worldview is. Now, is a worldview the same thing as political ideology? I don't know. I think in the cases that we've discussed here today, it may in fact be, and that's why we're running into a bit of a complication. But I'm going to continue to listen to the Q&A. I like you thoroughly. I don't think there's any doubt about your qualifications. Your lack of time on the bench is definitely a factor. But I think I told you when we met that I put a lot of weight into the notion that the governor is whether I know I can count on someone to fall on the right side or the same side as these many provocative issues that I might when it comes to political ideology and not necessarily just the letter of the law. But thank you very much, and I appreciate your patience, Mr. Chairman.
Thank you, Senator Sampson. Representative Blumenthal.
Thank you, Mr. Chair, and good afternoon, Attorney Danahy. Congratulations on your nomination, and I apologize for not being with you in person. I was in court this morning, actually at short calendar, and for the record, Representative Fishbein, I handled it all by myself. So many of my colleagues have asked questions that I might otherwise have asked, and so I'll try not to retread that ground. I did notice in the file that you provided, along with your nomination, you included a letter, I believe from 2009, from the Department of Justice's Office of Attorney Recruitment and Management, dealing with an investigation into a judicial finding of a Brady violation in the United States versus Triumph Capital Group case. And that letter absolved you of any wrongdoing or exercise of poor judgment, but it didn't include any of the details of the case or your involvement. I took a brief look at the case, and that didn't mention your involvement in the situation either. So I was wondering, could you please provide us some additional context of that case and the circumstances of your involvement, and also if you learned any lessons from that experience?
I can. The case you're referring to was United States versus Spadoni and Triumph Capital. That was a case that resulted from the larger investigation and prosecution of Paul Sylvester and others in connection with the corruption of the state pension system. The Spadoni was the general counsel for a private equity firm, Triumph Capital. After a long investigation, which included the cooperation of Paul Sylvester, a grand jury returned an indictment against Mr. Spadoni and Triumph Capital on several charges: bribery, I'll speak to Mr. Spadoni, bribery, obstruction of justice, racketeering conspiracy. In the course of that litigation, we turned over, specifically your question, I was the lead prosecutor on the investigation, and I would not call myself the lead prosecutor on the trial. That was a team of folks, very, very talented lawyers, one of whom is now sitting on the Second Circuit. So I was one of a team member on the actual trial. But in the course of the litigation, the government turned over voluminous records that included the reports of agents, of witnesses. Actually went beyond that, and it was very novel in Connecticut, at least in Connecticut, turned over the agents' handwritten notes that they incorporated into the written reports, did both voluminous bank records and other records. I sent out a memo because the case and the investigation had gone on for a while to the agents to provide all the materials for discovery and disclosure. For whatever reason, the handwritten notes that an FBI agent had taken of a proffer by Paul Sylvester's attorney, Hubert Santos, were not provided and not turned over. They were in the possession of the government, so I'm not giving that as an excuse, just to give you the context. After a jury convicted Mr. Spadoni on all but one charge, he appealed. In the course of that appeal, his new attorney asked specifically for the handwritten notes of the agent during the proffer session. Went back and learned that there was a handwritten note and handed them over. The Second Circuit reviewed it and found that the government should have disclosed those notes as part of the discovery process. As a result of that, I reported myself as the lead prosecutor to the Office of Professional Responsibility because there was no finding of misconduct, but I wanted, and it was appropriate under the DOJ guidelines, to report that decision to the Office of Professional Responsibility. So with the letter you see there exonerating me of any misconduct, and in fact finding that despite what the Second Circuit said, based on additional information, I didn't handle the appeal. Based on additional information, these notes were not even exculpatory. That's the background for that letter.
Okay, thank you very much for that answer. And it's very helpful context. Obviously the letter finds that you didn't do anything wrong. And so that's reassuring in itself. But the fact that you actually incited the investigation yourself by requesting it is also important information as far as I'm concerned. So I appreciate that. I don't have any further questions. I appreciate you being before us today and all your answers. I also appreciate the conversation that we had individually and the time that you made for that and your forthcomingness in that conversation. And I'm sure the conversations you had with other legislators. I noticed in the files that you received essentially a letter of recommendation from attorney William Dow, who is a very prominent criminal defense attorney. And I think that to me is an important credit to your practice and your character, as I'm sure he was on the other side of a lot of cases that you handled together. And the fact that he would report that you handled those cases in a way that he could recommend to us, I think is important. And I hope that as an attorney, I would have attorneys on the other side say that, but I'm not always so sure. And in any event, it's important information, I think, for our consideration. So thank you, Attorney Danahy, and thank you, Mr. Chair.
Thank you.
Thank you. Representative Dillon.
Thank you very much, Mr. Chair, and good afternoon and congratulations.
Thank you.
We had a very productive conversation, I think, where I raised a number of cases with you, and I'm not sure that it would be helpful for the process of the committee for me to go through every single Supreme Court case that I'm concerned about. But there were a number of procedural issues that I asked you about, and I wanted to revisit that, knowing that it's novel in a way because we've seen some unusual things happen with the federal Supreme Court. When you're looking to take into consideration any federal precedent on a question before you, should you be successful, it's my understanding that you would say the Connecticut Constitution comes first. Is that true?
Yeah, let me answer it this way. I think if I was reviewing a provision of the Connecticut Constitution, federal precedent would be one factor to look at, but not a dispositive factor.
And my concern was the increasing use of the shadow docket, which theoretically would involve procedural matters, but actually involved reapportionment, redistricting, that is, which had a political aspect to it, and the state police powers, which is what my friend and colleague from Eastern Connecticut was referring to. How much those cases were not fully argued, and yet decisions were laid down. If you're looking to attach weight to federal Supreme Court precedent, how would you deal with a case which involved a shadow docket decision, and whether or not it should have precedent, any value as precedent?
I think the cases or the matters you're talking about are where the court either weighs in to maintain a stay or not maintain a stay of execution of a judgment, which by in and of itself, may have a substantive effect. I'm not aware, after our discussion, I looked at the procedures for issuing stays and the ways to appeal that. So there's no shadow docket, in Connecticut. But if a yes or no really provides no guidance as a matter of precedent.
Well, I guess that because let's say if you take state police power, which was not invented by Governor Lamont, it's longstanding. And whether you agree with the individual actions that were taken or not, you know, whether you're ordering people to evacuate from Cape Hatteras or to stay at home in London during the plague, that's a well-established policy. But there was a case that went directly at the state police power, which was the Diocese of Brooklyn versus Governor Cuomo. The court, that case was actually mooted, but the court ruled on it anyway, and it was never fully argued. I know that you're kind of in a thicket here with my good friend from Eastern Connecticut on the matter of the pandemic response, but I just wonder how we're going to figure out how much weight to give to a case which was decided without having been fully argued on the federal level.
Guess what I can tell you is if I am so lucky to move forward, that any matter I approach, I would look to whether there's appropriate jurisdiction. As a jurist, I would be very cognizant that I have a limited role. So the first question is this, is there subject matter jurisdiction? So again, I can't tell you or explain what the US Supreme Court may have done in terms of that case, but I can assure you my approach would be to look to whether it's appropriately before the court as a threshold matter.
Thank you. And I don't know what the answer is, because I haven't really there was a lot of outcry about the Dobbs decision in the public, but there's a lot of other things that happened in that court that I think we haven't fully absorbed. And I don't know, what the implications are for the people of the state of Connecticut, but also for the authority of the legislature and of the governor. I don't know that. But I do want to concur with my colleagues' praise of my neighbor Willie Dow, and with your praise for Justice Kagan. I'm still just thrilled at her dissent in the West Virginia case on the EPA. It was just witty, but very, very brilliant. So I'm confident that you'll be successful. I think I should never say that in this building. But should you be successful, I think you'll serve well. And I appreciate your thoughtful responses.
Thank you.
Thank you, Representative Dillon. I don't see anyone else, and I don't see anyone online, so I'm going to allow Representative Fishbein to make a statement, and I have one question.
Thank you, Mr. Chairman. I have no question. One of the great things that I love about going to the appellate court, or, I've been before the Supreme Court, is to go and have a discussion about a case that I was immersed in. And, I have to commend you. People may not expect that from me today. But, you've been the case here today. We've been talking about you and your experience and all that stuff. And I've been watching you, and I think that you've done an incredible job here today. And I just want to thank the governor for his nomination. I will tell you that you have earned my vote here today. Initially I was quite adverse. We never did the one-on-one because I like having the public process, so that the answers are heard by everyone. I just, I really much appreciate the exchange. And I wish you good, this is probably when somebody goes on the bench, you can't just knock on chambers and go talk to them and stuff like that. So, we'll probably never have a conversation like this ever again in our lives. But I appreciate it. So
Thank you. I appreciate it. I do too. I hope we don't have this conversation again, but I'm happy to have a conversation.
Thank you, Representative Fishbone. So I just want to ask you one question. Actually, I had a whole bunch of questions. I was going to ask you about the rule of law and how that is not always worked for minorities and to opine. But I think the most important thing that you mentioned in your opening statement, and I think that is built throughout any person who says before us, whether it be for the Supreme Court or any other of our courts, is this concept of justice. Everybody talks about it, and I'm not always clear what they mean. And you may not be surprised to know that sometimes when I ask them a question about what do they mean, some of the answers are disturbing, actually. So my question is just about that, right? You laid it down as the foundation of what it is you are seeking. And so in your opinion, what is this justice thing that you're talking about?
Justice in my world is the fair and impartial and equitable application of the law. And that's what I try to do throughout my time as a prosecutor. And sometimes that meant not bringing a case, because when I looked at the facts and I looked at the law fairly and impartially, it just wasn't appropriate. Maybe there wasn't sufficient evidence. Maybe it was other reasons. So that to me is what justice is, not bringing my emotions to factor it in. It's to be fair, it's to be impartial, but it's also to appreciate the full picture of particularly at my role at the U.S. Attorney's Office, the full picture of a case.
I guess I'll thank you for that. And I would just say this. I think that the last part of your answer is, to me, probably the most important, understanding the full picture. There are a lot of folks who have been involved in our system in one way or the other, who talked about being fair and impartial. And that just gets to my question I often ask about the rule of law and how simply adhering to the rule of law can actually do a lot of damage because we're trying to be fair and impartial, but taking into account the context, if you will, I think is really important. So with that, I want to thank you for joining us. You have done a really good job of answering the questions to the best of your ability. And we have some other folks who would like to testify in this hearing. So thank you very much.
Thank you. I appreciate your time today. Thank you.
Absolutely.
Do I move?
Yeah, you don't have to sit there anymore. So we will begin with the public that is signed up to testify. We have Steve Kennedy, who is joining us online. Mr. Kennedy, are you there? And maybe I'll just say that so that people are aware, because I know we're transitioning. Mr. Kennedy will be followed by Christina Quaranta, Vesu. I'm gonna mess this up. Abherman. I'm sorry if I messed up your name. And Ivelisse Carrera. Mr. Kennedy. No. Okay, Christine Quaranta.
Good afternoon, everybody.
Good
My name
afternoon.
is Christina Quaranta. I'm the Executive Director of the Connecticut Justice Alliance. CTJA is a statewide youth adult partnership, and we work to end the criminalization of youth. We do this in many ways: organizing, policy, we use advocacy tools. And I'm writing today to urge you to reject the nomination of Nora Danahy to the Connecticut Supreme Court. While Attorney Danahy has significant legal experience, we've heard about it this morning, between working as a prosecutor, corporate attorney, associate general counsel. Her experience has been representing the already powerful rather than kind of the blue collar folks of Connecticut. And some of you have pointed that out this morning in your line of questioning, which I appreciated. She's also, from CTJA's perspective, advanced legal arguments that have actively harmed the communities that I work with daily. So as Deputy Attorney General, most of the cases where Attorney Danahy appeared were defending state agencies that were being sued. And most alarmingly for the organization that I lead, she argued several consolidated cases at the Supreme Court, including one called Justice W. Attorney Dennehy represents the DCF as it fought district court judges for using their discretion to impose shorter periods of detention for youth in DCF custody. So the concern there is just DCF was asking, or the Department of Children and Families was asking for shorter periods of detention, and she disagreed. We know, my organization knows, that detention itself, incarceration of young people, even for the shortest amount of time, leads to higher rates of rearrest relative to actually giving that child a chance at probation or other community alternatives, diversion, and also leads to them becoming more likely to be involved with the legal system as adults. So just beyond that point of arguing against shorter detention sentences is the area where Attorney Dennehy has spent most of her time. And we know that the Supreme Court currently is really made up of lots of folks that don't have a public defense background, legal aid, civil rights experience. That's something that we at CTJA would like to see, and others in Connecticut are concerned that we'd like to see the bench be more of those folks. So my closing comment to the Judiciary Committee, I'd just like to say that the people that you all represent up in Hartford, we're really counting on you to ensure that we have a voice in the court. And we would like you to send the message to the governor that CTJA and other folks in Connecticut don't approve of this nominee. We would rather have someone that really works for the people. And thank you for your consideration and listening to my comments this afternoon.
Thank you. Are there questions for Ms. Quaranta? If not, thank you for joining us again to express your concerns. Vasu Abhuraman?
Close. Thank you. No worries. Thank you, Chair Winfield, Chair Staffstrom, and esteemed members of the committee. My name is Vasu Abhiraman, and I am the Rosenthal Senior Counsel at Alliance for Justice, a national association representing more than 150 public interest and civil rights organizations. Since 1979, we've been a leader in advocating for a fair and independent judiciary that preserves access to the courts. I would like to speak to the importance of ensuring that the Connecticut Supreme Court is one where the justices come from demographically and professionally diverse backgrounds from the purview of state Supreme Courts across our nation. Nearly 2 out of every 5 justices on state Supreme Courts carry prosecutorial backgrounds, but only about 1 out of 10 carries a background as a public defender. Out of 345 justices nationwide, not even 25 have an extensive background in civil rights law, and barely 3% of state Supreme Court justices have backgrounds in civil rights law outside of government practice. Demographically, it's the rare state Supreme Court that has a justice who comes from the Hispanic, Asian, or from a Native American community. Connecticut is currently no exception, with no representation on the state Supreme Court from any of those key demographic groups. We would also encourage you to consider with each and every appointment the message that is sent to judicial candidates from historically disenfranchised communities who have, for good reason, often been reluctant to throw their hat into the ring for this process. Ask yourselves, does this appointment send the message that you can be anybody, work hard in the public interest with dedication, and become a justice on the Connecticut Supreme Court? Or does it send the message that you shouldn't bother unless you and your family are powerful and well-connected? Does it send the message that you will maximize your options as a lawyer if you confine yourself to corporate law or the DA's office? Or does it promote career paths for attorneys that include public defense, civil rights, legal aid, labor law, environmental law, reproductive justice, LGBTQ law? Lawyers who come from these backgrounds carry invaluable experience that would benefit any judiciary, including the Connecticut Supreme Court. Our justice system is built on the idea that the truth is born from diverse perspectives. If we want a judiciary that understands how to weigh complex issues with the interest of marginalized populations in mind, these considerations are paramount. We at Alliance for Justice, like all of you, want to work to ensure a fair and just judiciary that upholds the principles of our democracy for all. And we encourage you to ensure that the Connecticut judiciary, starting with the Supreme Court, is a shining example of demographic and professional diversity for states around this nation to follow, rather than shun. The good news is Connecticut is not left wanting for qualified candidates who would truly add professional and demographic diversity to the judiciary. But it's your job to ensure that they get a fair shake. In today's precarious environment, I'm sorry?
I don't know if you heard the bell, but the bell has indicated your time has elapsed. So if you could wrap it up, and that doesn't mean another 2 minutes, but if you could wrap it up, I would appreciate that.
Oh, sure thing. The people of Connecticut deserve true diversity on the Connecticut Supreme Court. State Supreme Courts are bulwarks for our rights. I yield for any question.
Thank you. And I hope this time when I said your name, I got it right. Are there comments or questions for Mr. Abiraman? Senator Kissel says he likes your background. Thank you for joining us today. Ivelisse Correa. Whichever one is closest to you, just make sure you press the button, and you have your 3 minutes to testify. Once you are ready to go, welcome back.
All right. Can you guys hear me? All right. I'd like to thank the Judiciary Committee for allowing me to speak today. There's only one day of summer left, and it looks like we're keeping things hot in here. I'd like to thank Nora Danahy for her time. She's a talented person and has a lot of talent, but Connecticut is currently moving in a new direction, and we should focus on representation. The only way we can turn Black and brown lawyers into Black and brown judges is to begin to appoint them, especially when we have an overrepresentation of prosecutors. We have no Black women on the Supreme Court in Connecticut, nor brown representation. We should take a look towards defense attorneys and civil rights attorneys for a varied perspective. Next, I come before the committee speaking for the voiceless, children in DCF custody. The last people ever consulted are the ones closest to the problems and those later impacted. Look no further than Connecticut prisons for the effectiveness of our DCF programs and the results for the youth who age out. Arguing to extend DCF detentions rather than integrate programs into the home for families not only saves taxpayer dollars, but it avoids adult custody in the first place. The state of Connecticut should be forced to periodically review why youth are being held in custody, which is why they have to remand juveniles every 18 months. In fact, we should argue that we should shorten that timeline from every 18 months to every 12 months, because that would force an educational, behavioral health, and mental health review every 12 months rather than every 18. Next is for the defense of civil asset forfeiture, which overwhelmingly impacted.
Ivelisse, I'm going to pause your time for a second.
Yep.
Are you testifying to the person in front of us? Because that's all.
So she argued for extending.
Okay.
The DCF custody for children.
I just want to make sure, because anyway, okay, your time is continued.
Gotcha. No, thank you for clarifying though, because it's showing up on a whole different person. I know people do that. All right. Next is her defense of civil asset forfeiture, which overwhelmingly impacted Black and brown people during the never-ending war on drugs. I'd like to remind everyone that while the state of Connecticut changed their minds on allowing cannabis legalizations when they needed to pay the bills, people who had the same idea are currently sitting in Connecticut prisons. We can't romanticize the laundered wealth of bootlegger-era outlaws like Al Capone or the grandfather of our last president, and then seize money from inner city residents here in Connecticut. There are already manners to deal with large cartels. We don't need to steal money from a pothead who carries a pocket scale to ensure his dealer did not short him. Civil asset forfeiture is wrong, and so is defense of it. And while I am a fan of her work in the Rowland administration, this appointment may also open up our courts to accusations of partisanship as a result. At this time, because courts' integrities are being questioned, I would also suggest that the Judiciary Committee move past her appointment, because we don't need any more partisanship in the state. Thank you very much. And I'm happy to answer any questions.
Thank you. Just so that we make sure we have done everything we're supposed to do, can you please state your name for the record?
Oh, sorry. Yeah, I was nervous. Evelise Correa, Ivelisse.
Thank you. Are there comments or questions for Ms. Correa? Comments or questions? If not, thank you for joining us again today.
All right, thank you.
I have been made aware that Steve Kennedy is actually on. Mr. Kennedy, you may testify. You have your 3 minutes.
Thank you. Distinguished members of the Judiciary Committee, I appreciate you taking the time to consider my testimony. My name is Steve Kennedy. I'm the Organizing and Network Director for the People's Parity Project, a nationwide network of law students and attorneys fighting for a justice system that works for the people rather than the powerful. I'm also a resident of Newtown and a graduate of UConn Law. PPP is part of the Connecticut Pro People Judiciary Coalition, a group of legal advocates, community organizations, disability rights advocates, unions, and attorneys pushing for greater professional diversity on the Connecticut State Bench. I'll try to keep this short because we have talked about this before, but we are concerned about the addition of more prosecutorial and corporate experience to the Supreme Court while there's still no justices with backgrounds in public defense, legal aid, civil rights, as Representative Osborne mentioned, nobody with family law. As we laid out in our written testimony, several empirical studies have shown that former prosecutors and corporate attorneys side more often with both corporate and state interests against those of the people that they harm. And I appreciate that some others have made a point saying that Attorney Danahy is not your typical prosecutor, but with no judicial record, the strongest data that we have are her experience. And reviewing that data, we're left to conclude that a vote for another prosecutor and corporate attorney is a vote for corporate and state interests rather than those of the ordinary people of the state. So I would just say that familiarity with someone's work ethic, character, and intellect, as it sounds like a lot of you have, is not the same as familiarity with their judicial philosophy. And from the outside, it does look like more of the same. Somebody who has spent a career on the overpowered side of legal conflicts, asking us to believe that decades of experience viewing the law from that perspective can be turned off after putting on a robe. And that's not what the data suggests. So regardless of the qualities of a nominee, they will bring their prior experience with them, and it's time we had more justices with experience representing people. So please vote no on this nominee and send a message to the governor that it is time for us to have a balanced bench. Thank you.
Thank you, Mr. Kennedy. There is no one else who has signed up, and so we are going to end the public hearing. I will tell the members that we are going to take a brief reset. I'm just letting you know, we are going to convene a meeting and take a brief recess so that everyone can come back fresh. You can take your bathroom break, come back fresh, and we will then reconvene the committee meeting and proceed with a vote on the nominee. So I'm calling this public hearing to an end. And with that, I will open the meeting of the Judiciary Committee for today, September 20th. And with that, I will recess it briefly, and we will be back. Thank you. Okay, we are going to reconvene the Judiciary Committee. We have one item before us, which is the nomination of Nora Dennehy to be an associate judge of the Supreme Court and a judge of the Superior Court.
So move. Second.
It has been moved and seconded.
Mr. Chair, just to be clear, this is just a motion for
To favorably report the nomination of Nora Dennehy of Glastonbury to be an associate judge of the Supreme Court and judge of the Superior Court.
Thank you.
You're welcome. It has been moved by Senator Kissel, excuse me, and seconded by Representative Staffstrom. Is there discussion? Representative Dubitsky.
Thank you, Mr. Chairman. And just a quick question, if you wouldn't mind explaining why this nominee is being nominated for both courts?
Through you, Mr. Chair, that is always how we do it. I believe perhaps LCO could explain better, but this is standard operating procedure in terms of the nomination.
I will throw that to the LCO if they would like to opine.
I'm looking for which statute provides that, but they are nominated to both courts. As is an appellate court justice or judge is nominated also to the Superior Court.
Representative Dubitsky.
Thank you, Mr. Chair.
You are welcome. Is there a question or comment from anyone else? I will just say this in one way or the other, the issue of what Nora Dennehy's background is has come into play about whether or not she represents the type of background, history, diversity of ethnicity, race, gender, all of those things has come into play during the conversation. There's been a lot of conversation about that. And I believe, and I do not always believe this, I believe that those comments have been heard and are being taken seriously. I believe there's a new understanding of the importance of this stuff to some of the people who are involved. And I think it's important to put that on the record. And then with that, Representative Porter.
Thank you, Mr. Chair. And I just wanted to put it on the record and state that through what I've heard with questioning and public testimony, I will be voting no today to flag this judge. Thank you.
Thank you, Representative Porter. Are there any further comments or questions? If not, Madam Administrator, would you please call the roll?
Roll call vote to favorably report the nomination of Nora Dennehy of Glastonbury to be an associate judge of the Supreme Court and judge of the Superior Court. Winfield.
Senator Winfield, in the affirmative.
Staffstrom. Flexer.
Senator Flexer votes yes.
Quinn.
Representative Quinn votes yes.
Kissel. Fishbein. Blumenthal.
Blumenthal votes yes.
Callahan.
Callahan votes no.
Conley.
Conley votes yes.
Curry. Delaney.
Delaney votes yes. He votes yes.
Representative Delaney again.
Representative Delaney votes yes. Delaney votes yes.
Thank you. Dylan.
Votes yes.
Doucette.
Rep. Doucette votes yes.
Dubitsky.
Yes.
Elliott. Gaston.
Yes.
Gilchrist.
Gilchrist votes yes.
Godfrey.
Godfrey votes yes.
Hall. Harding.
Harding votes yes.
Hayes. Howard.
Howard votes yes.
Johnson.
Representative Johnson votes yes.
Khan. Labriola. Lesser.
Lesser votes yes.
Marr.
Senator Marr votes yes.
Miller.
Senator Miller votes yes.
O'Day. Osborne.
Osborne votes yes.
Pavlock Tomato. Porter,
Representative Porter votes in the negative.
Sampson,
Sampson votes no.
Sims. Veach,
Beach votes yes.
Walker. Wilson,
Wilson votes yes.
Thank you. The votes will remain open until 3:30. So with that, unless my co-chair or the rank members have a comment, seeing they don't, we will stand in recess. Thank you.
Thank you.
Hi, Representative Smith. Hear me okay? Hear me or no?
Right, Representative Sims, do you hear me okay? Representative Sims? Representative Sims, can you hear me? I can't hear you. Did you-
Well, Christie,
Yes,
can you hear me now?
Representative. There you go.
Oh,
Yep,
okay. Yes, all right. Did you get my vote or no?
I did not.
Rep Sims is in the negative.
Okay, you're all set. Thank you so much.
Thank you.
Yep.
Representative Labriola and Representative Walker, let me know when you're ready to vote. Hi, Representative. Hi. So how would you like to vote on the nomination today?
Pavlik Tomato votes yes.
Awesome. Thank you so much.
Thank you.
Kirsten. Hello?
Representative?
Yes, this is Representative Walker.
Excellent. How would you like to vote today?
Yes.
Sorry about that. The camera. There we go. Excellent. You're all set. Thank you so much.
I didn't hear anybody coming back to vote, and I was in the other room reading. And so I said, well, let me go see. And then I looked down and they said, oh, the vote's been taken. I was like, what?
It was really quick, and we had people coming in the room too that just said the same exact thing. They were like, I just ran to my office to grab something and came back and people were filing out. So it wasn't just you.
Okay. All right. Thank you. Thank you. Have a
Of course.
good day.
Take care.
Thanks. Bye.
Hi, Representative Labriola. Hi, Representative, can you hear me okay?
Yes, can you hear me?
Yes, how would you like to vote?
I would like to vote yes.
Okay, you're all set.
Thanks a lot.
Thanks, take care.
Bye-bye.
Hey, Kristen.
Hi, Representative. How are you?
Doing good.
How would you like to vote today?
I like to vote yes. Sorry, I said Kristen, said Kristen. I apologize.
No worries. All right, you're all set.
Thank you.
Take care.